Parental consent definition, 34 CFR Section 300.9. Consent means that 1. The parent or adult student has been fully informed of all information relevant to the activity for which consent is sought, in his/her native language or other mode of communication. 2. The parent or adult student understands and agrees in writing to the carrying out of the activity for which his/her consent is sought, and the consent describes that activity and lists the records, if any, that will be released and to whom. 3. The parent or adult student understands that the granting of consent is voluntary on the part of the parent or adult student and may be revoked at any time. If a parent or adult student revokes consent, that revocation is not retroactive, i.e., it does not negate an action that has occurred after the consent was given and before the consent was revoked. If the parent or adult student revokes consent in writing for the student's receipt of special education and related services, the public agency is not required to amend the student's education records to remove any references to the student's receipt of special education and related services because of the revocation of consent. Parental consent, 34 CFR Section 300.300. Consent for initial evaluation. The LEA proposing to conduct an initial evaluation to determine if a student qualifies as a student with a disability must obtain informed consent from the parent of the student or the adult student before conducting the evaluation. Parental or adult student consent for initial evaluation must not be construed as consent for initial provision of special education and related services, and LEA must make reasonable efforts to obtain informed consent from the parents or adult student for the initial provision of special education and related services to the eligible student with disabilities. When conducting psychological evaluations, the LEA must implement the parental or adult student consent requirements of UCA 53-813-302, Utah FERPA. If the parent of the student does not provide consent for initial evaluation, or the parent fails to respond to a request to provide consent, the LEA may, but is not required to, pursue the initial evaluation of the student by utilizing the procedural safeguards, including mediation and due process. Special rules for initial evaluation of wards of the state. For initial evaluations only, if the student is a ward of the state and is not residing with the student's parents, the LEA is not required to obtain informed consent from the parent, if 1. Despite reasonable efforts, the LEA cannot determine the whereabouts of the parents of the student, or 2. The rights of the parents of the student have been terminated in accordance with state law, or 3. The rights of the parents to make educational decisions have been subrogated by a judge in accordance with state law and consent for an initial evaluation has been given by an individual appointed by the judge to represent the student. Parental consent for services. And LEA that is responsible for making a FAPE available to a student with a disability must obtain informed consent from the parents of the student or adult student before the initial provision of special education and related services to student. And LEA must make reasonable efforts to obtain informed consent from the parents or adult student for the initial provision of special education and related services to the eligible student with disabilities. 1. If the parents of a student or adult student fails to respond to a request for, or refuses to consent to the initial provision of special education and related services, the LEA may not use the procedures in Section 4 of the USPSARE, including the mediation procedures or the due process procedures, in order to obtain agreement or a ruling that the services may be provided to the student. 2. Will not be considered to be in violation of the requirement to make available a FAPE to the student for the failure to provide the student with the special education and related services for which the LEA requests consent, and 3. Is not required to convene an IEP meeting or develop an IEP for the student for the special education and related services for which the LEA requests such consent. If, at any time subsequent to the initial provision of special education and related services, the parents of a student or adult student revokes consent in writing for the continued provision of special education and related services, the LEA, 1. May not continue to provide special education and related services to the student but must provide prior written notice in accordance with Section 4D of the USPSARE before ceasing the provision of special education and related services. 2. May not use the procedures in Section 4 of the USPSARE, including the mediation procedures or the due process procedures, in order to obtain agreement or a ruling that the services may be provided to the student. 3. Will not be considered to be in violation of the requirements to make available a FAPE to the student for the failure to provide the student with the special education and related services for which the LEA requests consent, and 4. Is not required to convene an IEP meeting or develop an IEP for the student for the special education and related services for which the LEA requests such consent, Section 300.300. An LE may not use a parent's refusal to consent to one service or activity to deny the parent or student any other service, benefit, or activity of the LE, or to fail to provide a student with a FAPE. Parental consent for reevaluations. Each LE must obtain informed parental or adult student consent prior to conducting any reevaluation of a student with a disability. If the parent or adult student refuses to consent to the reevaluation, the LE may, but is not required to, pursue the reevaluation by using the consent dispute resolution procedures provided in the procedural safeguards, and including mediation or due process procedures. The LE does not violate its obligation under a child find if it declines to pursue the reevaluation. The informed parental or adult student consent need not be obtained if the LE can demonstrate that 1. It made reasonable efforts to obtain such consent, and 2. The student's parent or the adult student has failed to respond. Documentation of reasonable efforts to obtain parent consent. To meet the reasonable efforts requirement to obtain informed parental or adult student consent, such efforts must be documented and may include detailed records of telephone calls made or attempted and the results of those calls, copies of correspondence sent to parents or adult student and any responses received, and detailed records of visits made to the parents or adult student's home or place of employment and the results of those visits. Other consent requirements. Parental or adult student consent is not required before 1. Reviewing existing data as part of an evaluation or a reevaluation, or 2. Administering a test or other evaluation that is administered to all students unless, before administration of that test or evaluation, consent is required for all students. If a parent of a student or an adult student who is homeschooled or placed in a private school by the parents or adult student at their own expense does not provide consent for the initial evaluation or the reevaluation, or the parent or adult student fails to respond to a request to provide consent, the LE may not use the procedural safeguards, including mediation and due process procedures, and the LE is not required to consider the student as eligible for special education and related services. Parental opportunity to examine records. Parent participation in meetings. 34 CFR Section 300.501. The parents of a student with a disability or adult student must be afforded, in accordance with the state rules, an opportunity to inspect and review all education records with respect to the identification, evaluation, and educational placement of the student, and the provision of FAPE to the student. The parents of a student with a disability or adult student must be afforded an opportunity to participate in meetings with respect to the identification, evaluation, and educational placement of the student and the provision of a FAPE to the student. Each LE must provide notice, consistent with state rules, to ensure that parents of students with disabilities or adult students have the opportunity to participate in meetings. A meeting does not include informal or unscheduled conversations involving LE personnel and conversations on issues such as teaching methodology, lesson plans, or coordination of service provision. A meeting also does not include preparatory activities that LE personnel engage in to develop a proposal or a response to a parent or adult student proposal that will be discussed at a later meeting. Each LE must ensure that a parent of each student with a disability or adult student is a member of any group that makes decisions on the educational placement of the parent's student, including notifying parents or adult student of the meeting early enough to ensure that they will have an opportunity to attend and scheduling the meeting at a mutually agreed on time and place. The notice of meeting must indicate the purposes, time, and location of the meeting and who will be in attendance and inform the parents or adult student of their right to bring other individuals who have knowledge or special expertise about the student. Section 300.322b. If neither parent or the adult student can participate in a meeting in which a decision is to be made relating to the educational placement of their student, the LE must use other methods to ensure their participation, including individual or conference telephone calls, or video conferencing. A placement decision may be made by a group without the involvement of a parent or adult student if the LE is unable to obtain the parents' or adult students' participation in the decision. In this case, the LE must have a record of its attempt to ensure their involvement. Independent educational evaluation. 34 CFR Section 300.502. Definitions. Independent educational evaluation, i.e., means an evaluation conducted by a qualified examiner who is not employed by the LE responsible for the education of the student. Public expense means that the LE either pays for the full cost of the evaluation or ensures that the evaluation is otherwise provided at no cost to the parent. Right to evaluation at public expense. The parents of a student with a disability or adult student have the right to obtain an independent educational evaluation of the student at public expense if they disagree with an evaluation obtained by the LE. The LE must provide to parents or adult student, upon request for an independent educational evaluation, information about where an independent educational evaluation may be obtained, and the LE criteria applicable for independent educational evaluations. If a parent or adult student requests an independent educational evaluation at public expense, the LE must, without unnecessary delay, either file a due process complaint to request a hearing to show that its evaluation is appropriate, or ensure that an independent educational evaluation is provided at public expense, unless the LE demonstrates in a hearing that the evaluation obtained by the parent or adult student did not meet LE criteria. If the LE files a due process complaint notice to request a hearing and the final decision is that the LE's evaluation is appropriate, the parent or adult student still has the right to an independent educational evaluation, but not at public expense. If a parent or adult student requests an independent educational evaluation, the LE may ask for the parent's or adult student's reason why he or she objects to the public evaluation. However, the explanation by the parent or adult student may not be required, and the LE may not unreasonably delay either providing the independent educational evaluation at public expense or requesting a due process hearing to defend the public evaluation. A parent or adult student is entitled to only one independent educational evaluation at public expense each time the LE conducts an evaluation with which the parent or adult student disagrees. Parent-initiated evaluations. If the parent or adult student obtains an independent educational evaluation at public expense or shares with the LE an evaluation obtained at private expense, the results of the evaluation must be considered by the LE, if it meets LE criteria, in any decision made with respect to the provision of a FAPE to the student, and may be presented by any party as evidence at a hearing on a due process complaint regarding that student. Requests for evaluations by hearing officers. If a hearing officer requests an independent educational evaluation as part of a hearing on a due process complaint, the cost of the evaluation must be at public expense. LE criteria. If an independent educational evaluation is at public expense, the criteria under which the evaluation is obtained, including the location of the evaluation and the qualifications of the examiner, must be the same as the criteria that the LE uses when it initiates an evaluation, to the extent those criteria are consistent with the parent's or adult student's right to an independent educational evaluation. And LE may not impose additional conditions or timelines related to obtaining an independent educational evaluation at public expense. An independent educational evaluation conducted at public expense becomes the property of the LE, in its entirety. Surrogate parents, 34 CFR Section 300.519. Each LE must ensure that the rights of a student are protected when no parent can be identified for a student under the age of majority. The LE, after reasonable efforts, cannot locate a parent for a student under the age of majority. The student is a ward of the state under the laws of that state, or the student is an unaccompanied homeless youth under the age of majority. The duties of an LE include the assignment of an individual to act as a surrogate for the parents for a student under the age of majority. This must include a method for determining whether a student under the age of majority needs a surrogate parent and for assigning a surrogate parent to the student. In the case of a student who is a ward of the state, the surrogate parent alternatively may be appointed by the judge overseeing the student's case, provided that the surrogate meets the requirements. The LE may select a surrogate parent in any way permitted under state law. The LE must ensure that a person selected as a surrogate parent, 1. is not an employee of the USP, the LE, or any other agency that is involved in the education or care of the student, 2. has no personal or professional interest that conflicts with the interest of the student he or she represents, and 3. has knowledge and skills that ensure adequate representation of the student. A person otherwise qualified to be a surrogate parent is not an employee of the LE solely because he or she is paid by the LE to serve as a surrogate parent. In the case of a student who is an unaccompanied homeless youth, appropriate staff of emergency shelters, transitional shelters, independent living programs, and street outreach programs may be appointed as temporary surrogates, until a surrogate can be appointed that meets all of the requirements. The surrogate parent may represent the student in all matters relating to the identification, evaluation, an educational placement of the student, and the provision of FAPE to the student. The USPN staff must make reasonable efforts to ensure the assignment of a surrogate parent not more than 30 calendar days after NLE determines that the student needs a surrogate. Transfer of parental rights at age of majority. 34 CFR Section 300.520. When a student with a disability reaches the age of majority under state law, i.e., age 18, that applies to all students, except for a student with a disability who has been determined to be incompetent under state law, or the student with a disability marries or becomes emancipated. 1. The LE must provide any notice required by the IDEA to both the individual and the parents, and 2. All other rights accorded to parents under the IDEA transfer to the student. 3. All rights accorded to parents under the IDEA transfer to students who are incarcerated in an adult or juvenile, state or local correctional institution, and 4. Whenever a state transfers rights, the LE must notify the individual and the parents of the transfer of rights within a reasonable time frame.